Greetings. Greetings. This is the Public Podcast. We're going to open with a prayer from our Sarah Raha. My apology for a prayer from our Wazir, Sam Foster Bay.
Greetings to all. This will be the Moorish American prayer, which is called the map. Allah, Father of the universe, Father of love, truth, peace, freedom, and justice. Allah is our protector, our guide, and our salvation, by night and by day, through our holy prophet, Drew Ali. Amin. And now back to Wazir Milmore.
Thank you. Peace, truth, and clarity to all who are present and to all who are here to hear this recording. I am Wazir Ares Milmore Bey of Elodium, Moroccan, Pradium, Unte, Michigan. This is a formal public announcement and global podcast. We are broadcasting to let you know the issues under lawful authorities. So now, as we issue under lawful authority, now we must enter into the records of international, national, and local communities, seen and unseen, present and future. We stand here today not in opinion, not in debate, and not in confusion, but in record and in law and in standing. Let it be known, this platform is not a place for argument. This is a place where statutes is defined by law, not by narratives, not by assumptions, and not by misclassification. To the international community, we call your attention to the standing treaties, the recognized principle of nationhood, and the obligation that binds nations to honor their word. To the national bodies and international structures, we are hereby placing on notice for you to distinguish between rights and privileges, nationality and naturalization, statehood and stateless condition, and to correct the records where it has been misapplied. And to the local community, this is your call to awareness, to know who you are, where you stand, and under what authority you move. And to those who have operated on the system of control, colonization, misclassification, this is not for confrontation. This is for corrections of the records. The time of confusion is closing, and the time of clarity is now. We are here to establish and to demonstrate and to place on the records the distinction between dominion and land jurisdiction, the difference between Empire of Morocco and the Kingdom of Morocco, the line between nationality and naturalization, the condition of statehood versus stateless status, the function of council court, and the exclusive equity of jurisdiction, and the jurisdiction that govern us all accordingly. This broadcast stands as a living record with what is spoken here is not for debate, it is for acknowledgement. So let every ear hear clearly and let every record reflect truthfully. Where law defines status, everything changes. Now, at this time, we will proceed in order, and I will call on the first speaker. So the first speaker will be assigned to Wazir Yahya Abdul Bey. of New Al-Analusa, Florida. Thank you.
Islam, and greetings, everyone. It is my honor and privilege to do a brief discussion on the subject of dominion. And we will approach that topic from a treaty position to give, as the Wazir has stated, clarity to where we're going and what we're doing. There are many out there that are uncertain as to where we are. Actually, if we ask the question of many of the Moors, Negroes, Blacks, Coloreds, African Americans, if you ask them, well, where is this that we're standing on, or what land is this we're standing on? They'll tell you a whole lot of different places, but very few will say this is Morocco or this is the Empire of Morocco. And so we're here to talk about just that subject, the dominion, as it refers to, or as it referred to in the treaties. Now, when we talk about dominion, or when we use the word dominion in the treaties, and the treaties specifically that we're looking at are the Moroccan American Treaty of Peace and Friendship, or Amity and Commerce, more correctly, the Anglo Moroccan Treaty, or the Treaty of Madrid, and the Act of Algeciras, or the Conference of Algeciras. But the term dominion, as it refers to dominion of the empire, or the dominions of the, say, the emperor or sultan, generally means territorial sovereignty of the Moroccan Empire over the land and population. Now, historically, as we look at the treaties, we'll recognize that it was the emperor of Morocco, or the sultan of Morocco, that was approached by, well, we could say everyone else, to actually allow them to operate in those territories. And more specifically, we look at throughout the European arena, it was the Anglo-Moroccan Treaty that really set the stage, though we here at Morocco Major, and I say Morocco Major because the Moroccan Empire extended from Siam all the way to West Africa. And that's if, Siam is now called someplace like, Taiwan, that area. And if you travel you travel west, then you encompass the rest of the world all the way back to, and I said, West Africa. But of course, Morocco Major being here, North, South, Central America, and the adjoining islands. Because when historically, it's stated or proven that when the settlers or colonists arrived here on this North, South, Central America, and the adjoining islands, the Moors were here already. Between the artifacts, the historical writings from those explorers, they tell you, the copper-colored people were already here, which would identify the Moors. And so as a result, the rest of the colonists that traveled, say, anywhere they went in the world, basically, they had to receive permission from the Moroccan Empire to establish themselves, or to establish a jurisdiction. but we'll talk about that because when we talk about dominions, again, we're talking territorial sovereignty of Morocco over its land and population. But then there's a recognition that foreign nationals operating there or in our lands were within Moroccan territory. And therefore, um, it didn't automatically mean that um, we took full control over the foreigners uh, because we uh, because we are historically um, a cultural, social uh, uh, people who have for a long time governed uh, many nations within our nation state or within our empire. And so we understood what consular jurisdiction was about. So we would allow the foreigners to govern themselves or under capitulation. We would allow the foreigners to have their own jurisdiction within our empire without difficulty, problems. Of course, there were certain stipulations, such as taxes, complying with cultural, um, say, restrictions, and so forth and so on. But the idea was to give room for everyone to live in peace within the empire. And so, as we Moors um, return the empire to its former glory, then it is with that same approach or same attitude that we would use the treaties, uh, again, reestablishing the dominion of the territories, and then subsequently allowing for uh, consular jurisdiction. If you, the audience, should care to look deeply into that consular court, consular jurisdiction, you simply need to look at or review the Anglo-Moroccan Treaty of 1856. That goes into some details as to how the consular jurisdiction would operate. I won't have enough time to go into details, but again, Anglo-Moroccan Treaty of 1856. Look it up and read that through, and you'll come to a better understanding. And then for those who would say, well, what the English or Anglo-Moroccan Treaty got to do with, say, America? Well, they use the term or use a phrase in there which says most favorite nation clause, which means basically if it applied to one of the Christian powers or European powers, then the others were able to and I can say it in this case, they were able to piggyback on that. All right, but when we go into what the Europeans and American powers negotiated, they negotiated the rights that allowed their citizens to be governed by their own laws and consuls while in Morocco. But again, the dominion was still, that is, the territory was still that of Morocco. And we're not talking about the west coast of Africa. That was Morocco Minor. We're talking about Morocco Major, North, South, Central America, and the adjoining islands. So Morocco had territorial dominion. Foreign powers had jurisdiction over their nationals inside Morocco. This created a dual system and not just a simple hierarchy. That is, Morocco was not just simply superior and the other foreigners were subordinate, though that was the reality of the situation. But again, because of our cultural, say, acumen or understanding, overstanding of how people should work together, we allow for their say, jurisdiction within our jurisdiction. And so I mentioned the most favored nation clause as in that treaty of the 1856 Anglo-Moroccan treaty. That most favored nation clause allowed for and was used in multiple treaties. And it simply meant if Morocco gave one foreign nation a privilege, all other treaty partners could claim the same privilege. All right. And therefore, it multiplied foreign privileges inside Morocco, as the emperor or the sultan was making treaties all the time, because these foreigners within our empire were always seeking capitulations or seeking privileges. And again, citing that most favored nation clause, if I did it for one, then I got to do it for the other. And therefore, what we saw was it weakens Morocco's exclusive control over legal and commercial matters involving foreigners. And I said exclusive control. Now it becomes a shared jurisdictional issue, because any complaints or any discrepancies were solved through a consular court or consular intervention. And so instead of one bilateral agreement, Morocco was dealing with a network of equalized foreign rights. Okay, so what the 1856 and the 1880 treaties actually did, that is the Anglo-Moroccan treaty, expanded trade rights for Britain, and it limited Morocco's ability to control those tariffs and commerce once those tariffs were put in place. But it strengthened the protection over the subjects of the British. But then the Treaty of Madrid, it formalized the protected person system, and it allowed foreigners to extend protections to certain Moroccans, further eroding internal sovereignty. That is, we started to give away, Moroccan Empire, I don't know if it was naivety, that is, we were naive, or if we were just overcome by, say, these continued request after request. But you saw that the Moroccan Empire went from the exclusive control to a shared control to a subsequent. They were being actually at the close of the 19th century. The Moors were put in a position where they were virtually locked out of the control. But now the Treaty of Algeciras basically gave some outline as to how the Moroccan Empire would take control or dominion over that situation. And so I suggest you look at that Act of Algeciras of 1906, because there it lays out the basic principles of sovereignty and independence for the Moroccan Empire. It also talked about the protection or the guarantee of its domain, and then subsequently fair trade, which dealt with economics without any inequalities. And so I'm running out of time. It's just never enough time to discuss this. But what I want to conclude with is that as we return to our former state, that is, we are bringing the Moroccan Empire back, we are now using the treaties exclusively to reestablish where we're at, who is the sovereign of the land, and then all subsequent jurisdictions will be determined based upon the treaties and the sovereignty of the land, because the one who controls the land is the one who is absolutely superior in operations of jurisdiction. Okay. And with that, I'm going to have to yield. So peace and love, everyone. Look forward to talking with you all again soon. Islam.
Islam.
Islam. So I'm going to turn over now to the Wazir Mirmor Bey and allow her to cover the topic of the Moroccan Empire versus the Kingdom of Morocco. Islam.
Islam. Wow, that was very informational. So I hope everyone took information about the Dominion, because you're going to need it to add, as I add on to what our Wazir has brought to the table. As you met me before, I'm Mia Morbey, Wazir, head of state of a Loyal Moroccan Praying Unte, Michigan. And I'm going to today do my best to demonstrate the Empire of Morocco versus the Kingdom of Morocco. And hopefully when you leave this live today, you have taken something with you that you could hold tight to help you understand the difference between the empire and the kingdom. So let's move right along. Most people hear the word Morocco and they think of a nation state on a Google map or somewhere. But if you only see the map, you're missing the actual power of the empire. So there is a massive difference between the empire and the kingdom. And one is an ancient sovereign force, and the other one is a modern administrative house. If you don't know the difference, you don't know who you are. So let's get it into the records. So the empire, the sovereign atmosphere, before modern borders were drawn, there was the Empire of Morocco. This isn't just a country, it was a civilization, a nation force. Think of the empire like the atmosphere. It doesn't have a fence. Its influence goes wherever its people goes. Its laws and its trade routes goes. So the empire, and the lineage we are talking about was some heavy hitters. It was the Almoravid dynasty and the Almohad dynasty. So these power didn't ask for permission to cross lines. They established the law of the land. So their reaches expanded from a deep interior of Africa into the hearts of Europe, Andalusia, and across the Atlantic and into the Americas. So the power, it was multi-dimensional. And the spread of the math and the science and the build of the modern world and the control of the trade routes of the Mediterranean and the Atlantic. And this, as it is said in Psalm 72, verse 8, he shall have dominion also from sea to sea and from the rivers unto the end of the earth. This is the reaches of an empire, much, much different than the reaches of a kingdom. So now that we understand that an empire is about land, culture, and law flowing beyond borders, it is the high level of sovereignty. Now compare the Kingdom of Morocco we see here today with the empire. The kingdom is just like a house with walls, comparing to the empire being the atmosphere. And the status of the empire is much, much vaster than the status of the kingdom. So the kingdom, it is a centralized monarchy, recognized by the United States, the United Nations, the IMF, International Monetary Funds, and its functions operates as a country within a modern global political system, much, much different than the empire. And one thing about the kingdom, it has limits and it has borders and a defined territory in the northwest corners of Africa. So the key idea we must take away from a kingdom, it has territory limits. Its function as a modern political unit within a box created by the 20th century corporate maps. So the maps put the kingdom in a box. It don't put a box on the empire, because the empire is not all about landmass. It's about power that is massive, and it has no boundaries. So it is a house built long after the empire was established. So for the record and on the record, we must understand that the United States, aka the 13 collars, the vagabonds, that signed a treaty with the empire, not the kingdom. The kingdom of Morocco did not exist for 170 years after the treaty was signed. So who are the peoples in the kingdom of Morocco claiming to be the descendants of the people of the Empire of Morocco who signed the Treaty of Peace and Friendship of 1786 with the United States of America? So to understand this, we have to look at the true bloodline. Now, this is the big revealing that the history books try to cover up. When the Sovereign Empire signed the treaty in 1786, the bloodline was Almovad and the Almoravid and the Almohad, the indigenous dark-skinned and rooted in the ancient science of the land. So let's get into the DNA of the deception, because that's what we're dealing with. The people of the modern kingdom of Morocco today want you to believe that they are the same ones that signed the treaty of 1786 with the Empire of Morocco. But if you look at the genealogy and their culture, you see a trusteeship, not a sovereignty. So the true heirs of the Empire of Morocco were the descendant of the Almoravids and the Almohads. These were the indigenous dark-skinned masters of the Sahara and the Atlantics. The culture was rooted in high science. The same science used to build the mounds and the pyramids here in northwest of Mexico, as we see in Memphis, Tennessee, as we see in Mexico, and all along side of the Mississippi River that runs all the way from Mississippi all the way through the state of Michigan and Ohio and further. So their power was inherent. They didn't look for a European recognition. As we said before, they knew how to read the stars. And this is the bloodline of the people that signed the Treaty of 1786. They was actually the protectors of the Moorish nation. So these de facto replacement, which we can call the trustees. So who are these peoples in the Kingdom of Morocco today? Over centuries through Inquisition and colonization, and for the European nations scrambling for Africa, and the original imperial bloodline was pushed out and relabeled. So as they struggle over these resources in Africa, they was pushing us out and relabeling us. So we have to keep that in mind, that many of the current administration in the de facto kingdom are the Ottomans European of the Arazide descendants. They are not the Almoravid, the Almoravid and warriors. They are of deserts. They are of political trust put in place by the French and the Spanish protectorators. Their job is to act as buffers. They claim the title of Morocco to keep the vagabonds, the US/Europeans, in control of the Atlantic trade while keeping the true Moorish heirs in America stateless. The Black Negroes, Indians, and African Americans, This is exactly what the scripture warned about in Psalms 83, verse 4. It said, they have said, come and let us cut them off from being a nation, that the name of Israel or the true national identity may be no more in remembrance. Ain't that something? So the fraud of the signers, when the modern kingdom act as if they are the original signers of the treaties, they are committing identity theft, identity fraud. A trustee is not a beneficiary. The kingdom is the trustee managing the property. The national of the empire, they are the true bloodlines, and we are the beneficiaries. By pretending to be the empire, the kingdom helps the colonizers to keep the inheritance away from the true heirs. They are effectively holding your mail and telling the world you don't exist. So they keep the rent from your ancestors' land, as promised in the Treaty of Madrid, the Act of Algeciras. So we, as people, we have to come together and understand the difference of places and things. So as we look at this as generational, the people in the Kingdom of Morocco today has been doing a culture plug and play with the European system. They speak the language of the colonizers, followed by the law of the UN. But the true bloodlines, the ones who signed the treaty, carrying a culture that recognized the earth as the sovereign trust, they knew that Morocco was the global empire of the Forest West. The imposters in the kingdom are just a front office for the management company that is terrified of the landlords coming home and claiming the keys. The imposters are those who utilize all our resources and claim our kingdom, right? And claim our empire for their own. They have claimed that they was the one that signed the treaty. They have denationalized the Moors. So the difference between the empire and the kingdom of Morocco is vast. The Treaty of 1786 is still active. The empire was so vast and it went wherever the people went. So if you are more in America, the empire, its laws, it went with you. No matter where you stood on the ground, the law of the empire went with you. But when you look at the kingdom, the laws of the kingdom, it cannot go past its border in that little corner of Africa. So when we look at the U.S. founding fathers, they recognized the Moorish sovereigns in the Treaty of 1786. And they also recognized the 1790 Moorish Sundry Act. So when you say that Moors don't exist here in the Kingdom of Morocco, in the empire, here on this landmass, you are highly mistaken, because we have seen a history of timeline of the Moors being here on this landmass. So I just want to bring up one case that we all familiar with, and that's the case with William Dungeon, Abraham Lincoln. William Dungeon, his brother-in-law was accusing him of being a Negro, African-American, Black person, but he said, I'm a Portuguese of Moor descent. So that was Abraham. That is proof that Moors existed here on this landmass alone with the treaties. So I just want everyone to know before we end that Abraham Lincoln said this: my client is not a Negro. Through it is no crime to be a Negro. No crime to be born with a black skin. But my client is not a Negro. I say my client may be a Moor, but he is not a Negro. So the Treaty of 1786 is still active. If your ancestors built the mounds and the pyramids of this land, you are the heirs of the empire. Modeling labels like minorities are legal fiction designed to keep you from claiming your true jurisdiction, which is the empire. And the kingdom knows this, and they are aiding in your demise. So the difference between the kingdom and the difference between the empire cannot even be matched. So I yield and I thank you. Peace and love. Next, I bring on the next speaker that's coming with uh, San Foster Bay. Thank you.
Islam, peace, hotep, and ni hao. So that goes out to our Chinese brothers and sisters, you know. And if you know, you know. I won't want to get into that because that's a whole different topic. But yes, my name is Wazir San Foster Bay, and I'm from Umau, United Moroccan Allodial Anti-Ohio. And today I will be discussing difference between white rights and privileges. And so a privilege is something that is earned. It's something that comes with circumstances, rules, conditions. And as soon as you step out of that conformity, you're in trouble. You know, you're in the position to have everything taken away from you and having everything snatched. And an example of that would be like driver's license, gun license, fishing license, any type of license, any type of credit cards or anything of that nature. So to put it this way, it can be, if it can be suspended, if it can be revoked, or if it can be denied, it is what you call a privilege. And so the difference between rights is a God-given thing. It can't be taken away from you, and it's usually guaranteed by just your existence, just by you being who you are, being made of flesh and blood. So one of the examples is free speech, due process, and the equal protection under the law. So Trump made a statement that had everybody up in airs, and that was that the 14th Amendment was made for the children, the ex-slaves, and the ex-slaves of children. And so, you know, he was right about that because the 14th Amendment was established after slavery. It was a status that was given to slavery in which the status changed from slaves to person. And so, which, you know, coming up under the corporate citizen is a person that is given privileges, not rights. And so, in which you have to follow a lot of statutes, a lot of codes of the U.S. corporation. And if you don't, there's a penalty and there's a fine for that. So I will end on this note, and that is only becoming a free national can give you the rights. Going back to your ancestors' fig and vine tree is where you can find your freedom. And so our next speaker is going to be Wazir Simone Selket Bay El on nationality and naturalization. Peace.
Islam, Shukran, sister. Peace and love, everyone. Hopefully, I can break down this topic decently. I am Wazir C. Simone Selket Bay Il, the Wazir for Pal'Opi Allah, Nation State, Washington Ante Meridian. With that, the topic is naturalization versus nationality. And I think this can be broken down based on timeline, first and foremost. So we know for certain that the Treaty of Peace and Friendship was signed and ratified 1786 into 1787. So the question would be, what transpired after that time? Because prior to that time, we know that the United States was not a nation. So in 1790, the Naturalization Act took place. This act was specifically for immigrants coming into the United States. Its most advantageous clauses were for Europeans. So we would ask, why is there a law for Europeans to come to the United States if we think they were already here? Well, we know that they couldn't have been here because the treaty supersedes the existence of the United States government. So I'm going to read you just a little bit about the Naturalization Act. It was signed March 26th. It was the very first federal law governing the process of naturalization in the United States. It aimed to create a standardized procedure for immigrants to acquire citizenship. So let's just say the United States needed to employ people because they didn't have the ability to employ people on a land that wasn't their own. So, how would they do that? They would rally up their own people and bring them to a new land to stake claim to it. So in 1790, they offered Europeans citizenship on this land in order to overrun the landowners, which we know to be the Moors. The reason that the treaty is so important is because the treaty establishes the timeline in which who had territorial jurisdiction and who was paying rent. So the Naturalization Act was just the first act that allowed people, immigrants, to come here and to take up citizenship. Now, this wasn't American citizenship, this was United States citizenship. So that tells you that a specific body, group, or people were giving citizenship within that body, group, or people, and not outside of that. So then I would say, well, can anyone be naturalized? No, they cannot. If you were already here, you wouldn't need naturalization. You wouldn't need to acquire a citizenship because you were already present. But if you were new, you would need to be identified in a new way. So this is where naturalization came in. Imagine having a child in China, let's say, but you were Japanese. So you would have to figure out how to integrate yourself into the Chinese society being Japanese. So the Japanese person would then ask the Chinese, hey, I'm here, I'm chilling. I know this isn't my land, but what is it that I need to accomplish or do so that I can be intertwined in your community? That is naturalization. Now, let us say that you are Chinese and you give birth to a child in China. There's nothing that you have to do. You don't have to pledge an allegiance because that is your natural landmass. The same is true with the European immigrants migrating here to America. They came here and they had babies and they said, hey, what is it that I need to do to have some sort of relationship here? And we said, well, we can naturalize you. So this is the Naturalization Act. It is specifically for people who are immigrants and not those who have taken land ownership or have ancestors who are directly from or descendants of this specific landmass. So now let's talk about what laws were passed during this time. And I think one of the most important laws or legislation that was passed is the United States Oath of Offices. This was June 1st of 1789. So this is secondary legislation that asserts that the United States did not exist in any way, shape, or form here in the Americas prior to the treaty signing. So on June 1st, this is when all officers, public officials took their oath. So anything prior to that is irrelevant, doesn't exist, or is a lie. June 1st, 1789. So then I would say, well, when did they start breaking up naturalization and nationality? That transpired through the Census Bureau. The Census Bureau is how everyone was designated. Regardless of your naturalization, regardless of your nationality, there was a box that you needed to check. Why did they check these boxes? I think when you look at how limited the boxes are, you'll see that it was the first step of allowing people that were not free white persons to actually become free white persons. So I found it very interesting that the Naturalization Act was to specify who was a free white person and who wasn't. So the act restricted naturalization to any alien being a free white person. So this meant that if you were German and you came here, you couldn't say you were a free white person. If you were Italian and you came here, you could not say you were a free white person. If you were South African and you came here, you could not say that you were a free white person. Free white persons was specifically and expressly designated to people of Moorish descent. So this is where nationality comes in. I would then ask you, if you are born in Germany, your parents are German, that would designate you as German. Same thing would apply if you were in Iraq, you would be Iraqi. If you were in Iran, you would be Iranian. If you were in Sudan, you would be Sudanese. If you're in China, you would be Chinese. But if you're Black, would you be Blackanese? Would you be Blackacan? Would you be Black? I would ask you, what land do you come from? I would say, what land do Blacks come from? I don't think anyone can answer that question. And if you can answer that question and it starts and ends with Black, if that land is called Black and you can articulate that for me, I'll write you a check for $1,000. I know there is not one single person that could articulate that. So this is where nationality comes into play. Every people has a landmass in which is definitive. The most easy breakdown for the definition of nationality is the status of belonging to a particular nation. So if you cannot designate your nation, you cannot designate your nationality. If you cannot attach German to Germany, then you are naturalized. So I would ask you, Blacks, African Americans, what landmass do you attach your nationality? With that, I think we can easily see the difference between naturalization and nationality. And this applies in any country that you're from. If you're in Germany, but you're Japanese, you've naturalized in Germany. If you're in Iraq, but you are Sudanese, then you've naturalized. But if you are Canadian and you're in Canada, that would be your nationality. So when we think about this, every single European person that is here in America today cannot claim nationality on this landmass because their ancestors come from Europe. I would then wager every single European person hearing this or that you're friends with, ask them where they come from. Ask them what their lineage is. I guarantee you they're going to be able to say, oh, my family's from Europe. My family is British. My family is German. My family is Irish. They're going to be able to tell you a landmass. So, Blacks, I would ask you the very same question. What landmass do you come from? And on that, I yield. And I will pass it to Mia Moore so that she can introduce our next speaker.
The next speaker will be Aziz Hanoubei, Prime Minister of Skuru State Republic. And his topic will be stateless versus statehood. Thank you.
Well, thank you, Wazir Mir Moore. I am Aziz Hanoubei, Prime Minister of Skuru State Republic in the shared territory of the state of North Carolina, the colonial state of North Carolina. Yeah, my topic is statehood versus statelessness. Good afternoon. Today, we're not dealing with opinions, identity politics, or emotion. We are dealing in law. The subject is simple, but the implications are massive. Statehood versus statelessness. Because in law, there are only two positions. You're either recognized by a state or you're not. And everything, your rights, your protections, your estate, your heirs flows from that one distinction. So what is statehood? Let's define statehood properly. Under the United Nations recognized framework, specifically the Montevideo Convention of 1933, a state must have a permanent population, a defined territory, a government, the capacity to enter into relations with other states. Now, understand this clearly. In addition to customary law, Udi Possidetis Juris, our Moroccan treaties, and our enacted Moroccan law gives us full powers and authority. So statehood is not culture. It's not a skin color. It's not a social label. Statehood is a legal and political relationship. When you are connected to a state, the state can recognize you, protect you, and act on your behalf internationally. That's very big. What is statelessness? Now let's deal with the other side. Statelessness is defined under 1954 Convention relating to the status of stateless persons. A stateless person is someone who is not considered a national by any state under operation of law. This means no enforceable nationality, no diplomatic protection, no state obligated to defend your rights. You may have rights written on paper, but without a state, those rights often lack enforcement power. Now, misclassification and its legal effect. Let's go here. Now we address a critical issue, misclassification. Terms like Black, African American, Negro, Indian, Hebrew Israelite, and so many others. These are not nationalities in law. They are social or administrative labels. Under international law, they do not establish nationality, connect me to a sovereign state, trigger treaty protections. So let's be precise. Under the International Covenant of Civil and Political Rights, Article 24, and the Universal Declaration of Human Rights, Article 15, every human being has a right to a nationality and the right not to be arbitrarily deprived of it. So when a people are labeled or misclassified, but not attached to a nation, that condition can amount to what is called constructive statelessness. Now, impact on your heirs and their estate. Now we move into a part most people overlook: your heirs, your estate, and your legacy. If you are not recognized as a national of a state, your estate is handled under local statutory systems. Your property is treated as a subject and to administrative jurisdiction. Your heirs inherit within the same structure. Now, under the Hague Convention on Nationality, 1930, nationality determines a person's civil status and rights. Now, in the Nottingham case, ICJ 1955, nationality must reflect a real legal connection to a state. So understand this: if your nationality is unclear or absent, your heirs do not inherit sovereignty. They inherit liability and control structures. Next, allegiance and legal attachment. So what's the solution? Legal attachment to a state. When an individual declares allegiance to a state, they establish a legal and political connection. They enter into the state's jurisdiction. They become eligible for a state's protection. Under the Vienna Convention on Diplomatic Relations of 1961, states have the authority to protect their nationals abroad. So this is not symbolic. This is a jurisdictional reality. Now let's talk about the UNDRIP, the United Nations on Rights of Indigenous Peoples. Article 3, right to self-determination. This is a very powerful instrument. Article 5, right to maintain political institutions. Article 33, right to define identity and membership. This means a people have been misclassified. A people who have been misclassified have the right to reclaim their identity, reattach to their nation, and restore their political status. This is not theory. This is recognized international law. So the truth is clear and direct. This is not about what you call yourself. This is about what jurisdiction recognizes you. If you are connected to a state, you have standing, you have protection, you have enforceable rights. If you are not, you're exposed to systems that define you without your authority. So the question is not about identity. The question is, what state are you attached to? And can that state act on your behalf? Thank you, Islam. And I'll hand it back to Wazir Mir Moore for the next Wazir. Peace.
Islam.
Islam, my apology, Joshua. Islam, thank you. Next week, our next speaker will be Joshua Bayel from a new Manhattan, Pradium, New York. And his topic is equity in jurisdiction.
Islam, everyone. Greetings. My name is Joshua Bayel. I'm the Wazir al-Rayez for Anu Manhattan Palladium, Ante, New York. And I'll be going over consular court and exclusive equity.
Islam Wazir, point of interest, did you know that your camera was off, or you wanted to stay?
You can see me now?
Yes.
Okay. I'll be going over consular court and exclusive equity. So what is exclusive equity? Equity is a jurisdiction, it is a realm, and it is a container. It is many things. It is one of the words used to describe a meeting of the minds. Since all law is one and everything's connected back to the Creator, even things like church and state have to have a meeting of the mind in order for there to be peace and harmony within the land. So with that being said, an exclusive realm was put together, much like the Garden of Eden. And we, as stewards, as beneficiaries and children of the Creator, we are endowed with certain responsibilities. And one of those responsibilities is to know the difference between our jurisdiction, our realm, from which we come, because all creation stems from the source, which we recognize by many names, but one of those many names is Allah. And more science, that'd be our self-Lord and Master in what we would call Islam. So the master of the universe, the architect of all things, creator of all things, comes from one source. And that one source, we agree, is within. And that is what connects us all. From that point moving forward, the realm of equity was an exclusive and private manner of doing business, which was taught to the royal families by the nobles. And the nobles would be the Moors of the vast empire. And they taught the royal families, which came much after, how to conduct their court. So the judges back in this time, going all the way back to the 1300s, the 1200s, the 1400s, the 1600s, etc., going all the way back to even antiquity. Even before, how would you say, when I say antiquity, I mean time. There was a time where there was never a time where man was not. So dealing with equity, you're dealing with how did a certain jurisdiction come about, how far back does it go, equity supersedes at law. At law is what lawyers, attorneys, judges, and colonists, they use this particular system known as at law. Now, what is at law in comparison to equity? I'll give you another example. Equity is in, it comes from within, and then comes out forward and makes its contact with the outside world. But prior to doing so, it announces itself, meaning before a noble or even a royal steps into a room, there is an announcement, right? Of here I am now proceeding. I've sent in paperwork. You should know who I am and what I'm doing here, right? The angels make an announcement before the judgment of the Lord. You know what I'm saying? Before the king, the queen, the emperor, whoever, there is an announcement, right? To let you know what the jurisdiction is, right? And at law tries to do something similar by saying all rise, and they start making announcements and pronunciations, right? Now, I'm going to start making sense of a lot of metaphors, but I'm going to keep it extremely practical so you can have a certain level of imagery in your head. So, the king, for lack of better terms, and the church, they were in their jurisdictions, and they were pronouncing judgments within their jurisdictions. And then those pronouncements had to be known to the world by giving decrees, right? You have judgments and you have decrees, right? You have motions and you have petitions, etc. So the Court of Chancery, what that jurisdiction predates the at-law jurisdiction, and over time, the colonists realized that they could use the at-law jurisdiction and overrun the natural way of doing things, which was inequity and fairness. So equity deals with at least 20 principles, and I'll give you a few of them right now. Equity sees that what ought to be done is done, much like the 12 commandments. Equity will not allow statutes and codes to be used as a cloak for fraud. Equity delights in equity. If you expect equity, you must do equity. Equity requires that you approach with clean hands. Equity rewards fairness. Equity can reach back in time and fix something that was wrong and make it current, right? What else? Equity abhors a forfeiture. Equity will not reward a volunteer. Equity does not participate in the half fulfillment of a duty or a gift, right? So equity does not aid of not only a volunteer, but equity does not aid one who slumbers upon their rights. Now, if you do not know your rights and that you have the ability to step into equity, right, to activate it, to use it, not only for your personal affairs, but to govern your state, your estate, and to govern your actual state. So this type of law and system was in place, but kept over time more and more quiet, where by the time the 1700s were rolling around, the British Association registry system was starting to take over the legal system. And when I say take over, to infiltrate, because in the 13th Amendment, it says that anyone who is elected into office in the 13th Amendment and its 20 sections cannot be a part of the Bar Association and occupy an office in government. That would be what you would call breach of trust. Now, the land, the Constitution, and the resources is trust property, right? And these civil servants are known as trustees, right? Civil servants slash trustees. And now, when a trustee starts acting like a beneficiary, when a trustee starts to separate the people from the resources, this is a breach of trust. I'll give you another example. Water is a natural resource. You need water to survive. Water is something that you need to continue living healthy. If the colonist or if a trustee now decides to poison the water, and at the same time erect companies to sell you water, right? This is a breach of trust. Okay, so I'm giving you many examples in a metaphor and a realistic sense so you can see how this works. So the Treaty of Peace and Friendship was signed as a trust, and all those who signed it were given duties, right? They had obligations. You cannot enjoy the benefit of the contract if you do not fulfill the obligation. So the obligations are written in the titles. And if those obligations are not fulfilled and you can't hold on to property and then deny that you are a trustee holding property when the beneficiaries, the people, decide to wake up and say, I've created and constructed a trust, or there is a trust already been created and I'm identifying myself as the beneficiary of said trust, and you as trustee, I'm appointing you with certain specific duties to extinguish any obligation based on the proceeds and the fruits of the labor of the resources that have been so abundant that you yourself have been in control of and benefited from, but refuse to release the interest, the proceeds, and any of the resources that is entitled to me by God-given right and law. So now when you decide to construct, it's very important to construct a trust, not just claim beneficial interest in something that pre-exists. You, the people, we must construct a trust, and one of the ways of getting ready to construct the trust is the registered mail number. That registered mail number lets the world know the name of your trust. That registered mail number, now you're starting to use it to actually form creation right in front of them. As a child of God, you have the ability to create something and co-create right in front of them. So what are you creating? You're creating an equitable trust in its equitable private jurisdiction. So you have the registered mail, you mailed it back to yourself. Then you have the table of authorities. What are the rules and regulations of the trust? Then you're saying, here is the intent of, after I've given you the name of the trust, the table of authorities, what my intent is, because no one can read my mind until I put it on paper and give you notice. Now that I've given you notice and I've even appointed trustees, maybe the opposing party that I'm talking about is a trustee. That stops the prescription. What is the prescription? The prescription is an entity, an attorney representing an entity claiming that you owe, right? And that prescription could be a bill. It could be a summons. It could be a judgment. These are prescriptions. You can stop the prescription once you've acknowledged and you've given notice that you've acknowledged that you've accepted this prescription. You've claimed it as property. Notice the trustee, now that that property and the office that you occupy is now trust property, and now I'm giving you instructions to what to do with my property. I'm stepping out of town, or I'm going to be, away for a while. And if you've already had custody over this account, you've had custody over this property and the resources. So the to bring this home, the legal system, right, which is at law, in comparison to the in-law, when you marry someone and now you have a contract, another trust contract, right? You must redefine your relationships in all these trust contracts. And now you're saying, hey, me and my spouse got married, and the state wants to be a part of it. The state wants to be a what? A trustee and a beneficiary, because they're hoping that you would be trustee in suretyship, meaning they're going to create an instrument, they're going to benefit from it, and they're just going to slide it past you that they are now a third party in the trust relationship, and they get the benefits and you do all the work and all the suffering. So your spouse's parents become your in-laws, not your at-laws. See the difference between in-law and at-law? Attorneys practice at-law, right? At is near. It's not in, right? It's not coming from within. It's not part of that private relationship, right? And our relations, our contracts, our agreements, our intimate relations are all coming from within and from behind closed doors, right? Which is private. You have the right to privacy. Even the Constitution says you have the right to privacy. But if you don't assert that right, then they just say, well, well, everybody, So then they're expecting you to do what? Practice intimate acts in the public. And those intimate acts can be dangerous because you can acquire social diseases like greed, social diseases like usury, social diseases like lack of empathy. A corporation don't have no feelings, so they'll put a mother and child on the street and not feel nothing, knowing that they used that mother and child social security number to create a security, which created the trust, and then they're benefiting from it and got the resources, right? Sound familiar? Got the resources from the mother and child, but yet still try to put them on the street. Now, a good beneficiary, a good executor realizes what's going on and says, whoa, wait a minute. We got to stop this. I've been appointed as a friend of the court, as a consular officer, or even in some cases a trustee, and all the other trustees were fired for lack of competency because the trustees now, who, let's say years, all the people who were parties to signing the treaties and active Aldosiris, etc., they're going to say, well, that was a long time ago. That has nothing to do with now. Well, according to the France versus the United States in 1956, United States was able to benefit from that trust relationship between the Moors by using the treaty, the trust, right? And stating that if we have a problem, according to the trust agreement, the treaty, highest law in the land, we're supposed to go to consular court, not the ICJ or any other court. Consular court, 1. 2, you are not the beneficiaries. The United States said this, that to France, you may have been named protectorate, but you're not the beneficiaries. You're a property manager, a trustee, if you will. And you don't have the right or the ability a trustee can't appoint nobody. So what happened in the findings of that case? The ICJ said, you know what? Not only are you right, but the Moroccan Empire has not lost its sovereignty or its ability to contract. Pause. Stop right there. Nobody move. Right? Freeze frame. Pull out the forensic audit. Pull out the forensics of the murder scene. Where was the murder? There was a tale that you were lost at sea, right? And could not be found. Therefore, your property was held in trusteeship as a minor, and you didn't come to the awareness that you are a beneficiary not only of this vast estate, but all the proceeds and everything that they've been benefiting from. And you had to speak up and to be known. If you're in class, they call your name and they see you, but you don't raise your hand and say, I'm here, then you can't receive the benefit. And you didn't let them know that not only am I here, but I want my lunch. I want all the tickets and all the parental notices and everything that's supposed to come that I'm supposed to get while I'm here in school today. And y'all can't take advantage of me because I know my rights, right? So now, fast forward. In equity, you have in-laws, not at-laws. You have rights that come from within, which what they call unalienable or inalienable rights. Well, let's break that word down. Inalienable. In or at? Does it say at alienable or inalienable? In. So that those inalienable rights are coming from where? From within. The whole crux of our mindset and reality of our, what you would, lack of better terms, call religion and nationality, is that a law is within. All the laws and everything that came from creation comes from within. So those same rights in equity are coming from within. Fast forward. So every contract you've ever signed, anything you've ever agreed to is a trust relationship, right? And you learn how to reestablish your position as a beneficiary, and I myself as a co-beneficiary with my sister states. They also benefit from the resources of the land. They also benefit from this shared jurisdiction because the land is so vast. But we as a whole had to let it be known that according to, like I said, the Act of Algeciras, they mention taxes to be paid in Article 67 of the Act of Algeciras. These are proceeds since 1906 to present date. Who was supposed to be collecting that? The United States said, I don't want to be responsible for collecting Moroccan taxes. France jumped up and said, ooh, I'll collect it for Morocco. And the United States said, and they both went to court to argue about our proceeds, our equitable trust res. The proceeds, the money that was supposed to be collected, the rent, if you will, the zakat, the tribute, etc. It was supposed to be paid to our government, but Moors weren't aware enough at the time, anywhere in the 13 countries, including the United States, to step up. And they could have came back with France and say, here we are. I'm president accounted for. We may have lost that case because we weren't present. We here now, and we were unaware of our rights in equity. And now we're in our right mind. And now, because we're in our right mind, we're using this opportunity now to release what? The latches. Latches, another term that when you sleep and slumber upon your rights, they put something called latches, almost like a statute of limitation. Who's doing that? Well, that's where the legal and the legal system and the equity system are struggling right now. And then you release the latches by saying you are now aware of your rights in equity. And now you are exercising those rights to release the what? Latches, right? Release the latches. Now what happens? Now you start quoting and showing and proving the trust was constructed. My intent was clear. The delivery was proven. I identified the beneficiary, identified the trustees, those who benefited and occupying the office. No matter who's occupying the office, you claim that the office is trust res. So even if they change offices, the office itself is trust res, including the resources that they control, the accounts, the water, the lights, etc. Right? So now you've included some of what your property is: access to these accounts, access to the resources, access to the land, access to the proceeds that you as a Moroccan and your state was supposed to receive since 1906 to present date. So now what are we talking? Who's holding the money? The comptroller of the currency. The comptroller is holding the currency in trusteeship. He's holding your property, right? He's not a beneficiary, he's a trustee. So when you and your state come together now, because I'm giving you what is the benefit of us coming together and organizing for what? So we could wear this funny headgear, right? Looks nice, doesn't it? But it's more than that, right? You have to handle your business on the earthly plane and set your mind on things that Allah has already set aside. Now, why would the Creator give you all this benefit if you didn't know how to protect it? You got to have a protector. The beneficiary is a protector also. A trustee can be one, but the trustee can get fired if they're not doing their job. So what is Allah? Allah is the father principle. What's his job? To protect the resources. Who's mining the resources? Mommy. What is another name for the abundance of Allah? A lot. Abundance, a lot, right? A lot is the feminine principle of Allah. But why would Allah give you something, right? Just give it to you without showing you how to protect it. So you have to have the protectorate energy. The father and the mother work together. So the father protects the resources that the mother and the father are using, right? So the Creator gives the father principle enough energy to protect. You're okay back there, mama? All right. And anything that I get, I'm giving it to her so she can do what? Multiply it. I give her food, she gives me a meal. I give her a house, she gives me a home, right? I give her money, she makes investments, right? I give her seed, she gives me a family, right? So everything I give her, she multiplies, she grows it, right? So now, why would you start off with all this abundance without the protection? We're living in a very savage reality out there in the public. It's very savage in the public. Where is the cultivation and peace and harmony and those relations like mom and dad once had? Where are those established? In the private, in equity, in law. So before dad goes outside, he says, Mama, I done changed the locks on the door, installed a new alarm system. Here's my emergency number. Here's some extra money. You take care. You run. You are in control of the whole estate. And call me if you need anything. And there's extra security in the back if you need that. And I already showed you how to, okay, protect the resources, Mama. I'll talk to you later. I'm going to go out and go get more resources, right? So Dad done did his job and helped and gave Mama a lot of resources, abundance, and said, I'm going out to go get some more. You take care. Call me if you need anything, right? So that this is another example of how equity works. Now, fast forward. What happened in equity? The Vatican, right? The Vatican stepped up and said, hey, France, don't you dare go back to the International Criminal Court, taking the United States or any other country to the International Criminal Court, talking about Moroccan taxes, Moroccan laws, Moroccan proceeds, Moroccan empire. Quiet. Don't talk no more about no Moroccan anything, right? And what happened around this time? This is in the 50s now. Fast forward, 1956 to 1952. That's 4 short years. The Kingdom of Morocco jumps up, pops up out of nowhere, right? And they're like, ooh, okay, this is nice. And they trying to look and sound like us, but they're not the beneficiaries because the treaty names the beneficiaries as Moors, right? We were smart enough and wise enough, even though we came from many clans. We said, how are we going to identify ourselves? Because we used to fight each other about what we called ourselves. So we got to stop fighting enough so that we can make our life and our lands abundant before these new people get over here. So they said, you know what? We're going to call ourselves by the name and the spirit that pulled us all here together. The most powerful force in the universe, como se dice, love. And how do you say love in Latin? Amor. So they agreed to call themselves Moors, right? Under this title, under this umbrella, so it would cover in equity, right? Your rights, your treaties, your proceeds, the spirit, the love, truth, peace, freedom, and justice. All of that encompassed into what you would call a word, right? And that word is love. So in law, it's amor, right? In practice, it's equity. So equity is not only private, the difference between your thoughts, your private relations, they're private, right? Private agreements, trust agreements. Those private agreements cannot be commingled with the enemy belligerents of the public because we've been infiltrated. We've been occupied. And our forefathers and foremothers knew that if you commingle, right, the equity with the at law, not only would you see infiltration, you're going to see corruption. You're going to see gangrene. When an arm is cut and it bleeds, and anybody with some sense would tell you you need to get that cleaned up. You need to get that taken care of and disinfected and dressed and covered, right? Okay. What happens if the cut don't get cleaned up, dressed, and covered? You get an infection. You get gangrene. You could lose the arm, right? Just like you lose your mind, right? Okay. So now, what happens now is that you clean it, you disinfect it, and you dress it, and you cover it, right? So the infections of the public, of the outside world, don't get in there and mess you up, right? And if you don't think that the world is messed up at law, read the papers, listen to the news. They mixing everything. There's pork in the toothpaste. There's pork in the cereal. They poison in the air. So we're gonna have to learn how to draw a line and say, hey, no fly zone. Don't spray that stuff over here. This is private. This is equity. This is, and we're gonna have to step up. So the most beautiful and scariest thing in the world is when we decide we have more in common than we have that separates us. And that thing, that unifying force is a law, right? And then how do we get back to equity? State your claims. Your registered mail, construct your trust, get with your Moroccan state, right? Because the colonists are not scared of treaties. They're not scared of the law. What they're scared of is you knowing the difference between at law, equity, public, private, treaty, colonial, empire, kingdom, right? And the difference, and the knowing when they are talking to you and when they're not talking to you. Example, in the Bible, it says, slaves obey your masters. But in that same book, it says, everywhere where the sole of your foot shall touch shall be your land, and no man shall be able to stand against you, because as I was with Moses, so shall I be with you, for this is for the inheritance of the land. So slaves don't inherit land. They don't.
Islam.
So it just goes to show you that when you know who they're talking to, and if you know how to answer questions, because the king or the one in authority is always asked king, right? And you start
Islam.
breaking things down and making sense of it. Is that public? Is that private? Is that equity? Is that at law? Is that treaty? Is that statute? Is that code? Is that kingdom? Is that empire? Is that African American, black, colored, Negro, or is it a Moor? Right? Right? Is it indigenous?
Islam, brother.
Right? Is it
Yes.
indigenous or is it
So with that,
an Indian? So
all
with that,
right.
I would like to say that please get with any one of your Moroccan state officials, simply because there's more than meets the eye. We don't have it all, but we have enough common sense to know that the world needs all of us right now. When the rest of the world decides to get under the treaties of peace and friendship, then love, truth, peace, freedom, and justice can reign for all. And I say that with love in my heart, because look at what's happening. Would you rather love, truth, peace, freedom, and justice, or the current condition? And if
It's
you you're in any one of our states, please reach out, because we would love to see more amongst our ranks. Because we're not asking for you to get involved with something that is just a social club. It's a divine and national movement. It is a government, and it is holy Islam.
Islam, brother. Thank you for bringing that. Thank you. And I wish we had more time to go, because our brother was really bringing the truth. He was really bringing the knowledge. There's nothing more powerful than this land and our equity that is due to us all. So, as we bring this Moorish International Legal Forum to a close, we stand united in our mission to reclaim our ancestors' heritage and transition from corporate legal status back into our true lawful identity. So I'm going to pass it over. And before I pass it over to our Wazir Yaya to close us out, I'm going to give thanks to all the Wazirs here today that presented the information, all the Wazirs. And I pray that you are guided in, we're guiding the world into restoration. And we are encouraging all of us to still participate, to maintain this momentum by continuing to work of the work of self-government and state and reclamation. And let this be the beginning of a new chapter in our collective sovereignty. Peace, blessing to the ears, and look forward to our continued progressing through the Council of Imperial States. So I'm going to turn it over to Yahya Abdul Rahim Bey of New Al Andalusia to close us out.
Islam. I ditto, or I I agree or concur with Wazir Mir Bey. I wish we had more time. Um, these topics, the dominion of the Moroccan Empire, and the rights that are inherent in our nationality and statehood, bringing us together or bringing us to that realm of equity where we find absolute remedy. Moors, Negroes, Blacks, Colors, African American, all of us, we are in need of unity more now than ever before. As we look about the world is like they're choosing sides. So let us Moors come together under, as the brother just said, under amor, under love. That's the highest principle. And so, as we close out here today, I'm going to ask everyone that has viewed this or take the time to go back and view, leave some comments as to what you would like to see us, topics that you would like to see us approach. But more than anything, I'm going to ask for the other states that may not be associated with us. Please consider joining the MUSIC, that is the Moroccan Universal Supreme Imperial Council, as far as a coming together of the Moors so that we can unite and forge a unity that cannot be broken. And as we leave this place, we say, in the name of the creator of all things that has guided us to this place, that has brought our hearts and minds to a point where we can now actually focus upon that which is most important and step away from the distraction, focusing on that which uplifts fallen humanity. We seek the guidance and continued love from the Creator that we might leave this place and take up arms to do good in all the cause of the Moors. And as we return to this place, let us return with good reports of our actions as we come together again. And I say, in the name of the Creator, all that is good, the all, Islam, Ashe, I mean, so mote it be. Peace and love, everyone.
Peace and love.
Peace
Peace
and
and
love
love.
to everyone. Peace and
Peace and
love.
love,
Peace and
everyone.
love.